The silence in that Melbourne courtroom was absolute, heavy with the weight of unspeakable acts and shattered lives. Every eye was on the defense barrister as he rose, his voice cutting through the tension, making a statement that would reverberate far beyond the walls of that building. His client, Rayyan El-Houli, wanted nothing to do with violent jihad. She renounced it. She renounced Islamic State. This wasn't just a legal defense, it was a public declaration, a moment of profound significance for a woman accused of the gravest of offences. A woman who had travelled to a war zone and returned to face the full force of Australian justice. The question hanging in the air thick and unasked was whether anyone believed her. Before Rayyan El-Houli became a name whispered in hushed tones across the nation, she was in many ways an ordinary Australian woman. Born and raised in Melbourne's outer suburbs, perhaps in places like Broadmeadows or Dandenong, her early life would have been familiar to many. She'd gone to local schools, navigated the complexities of adolescence, and lived within a close-knit community. She was 34 years old when her name hit the headlines, a critical juncture in life where many Australians are building careers, starting families, or settling into a comfortable routine. Imagine her friends, her neighbours, perhaps her work colleagues, people who saw her at the local shops, at family gatherings, living a seemingly normal Australian existence. What was going through their minds as they watched the news reports, seeing a face they recognised, linked to a world so utterly alien, so brutal, so far removed from the everyday concerns of mortgages and school fees? Her family too would have been thrust into an unimaginable spotlight, grappling with a private agony that became a very public spectacle. The suburban quiet of her upbringing stood in stark contrast to the global nightmare she would eventually become entangled in. A journey that would lead her to the heart of a declared terrorist organization and then back to an Australian courtroom, facing charges that carry some of the most severe penalties our legal system allows. Her story is a stark reminder that even in our peaceful multicultural cities, the tendrils of international conflict can reach deep into individual lives, pulling people into currents they may not fully comprehend until it's too late. The incident that brought Rayyan El-Houli to the attention of Australian authorities was her decision to travel to Syria and allegedly join Islamic State. This wasn't a spontaneous act, it was a deliberate journey undertaken at a time when the world was watching in horror as ISIS carved out a brutal caliphate, committing atrocities that shocked even the most seasoned observers of global conflict. It was around 2014 or 2015 perhaps, when the group was at its terrifying zenith, that she made this fateful choice. Details remain scarce, but we can surmise the path: a flight out of Melbourne Airport, a journey through various transit points, and then the clandestine crossing into Syrian territory, into a land gripped by war and extremist ideology. What led her there? Was it a profound ideological conviction, a desperate search for belonging, or the insidious manipulation of online radicalization? For years she was effectively off the grid, living under the so-called caliphate, her life a world away from the familiar rhythms of Melbourne. We don't know the exact nature of her activities there, whether she was an active combatant, a supporter, or simply a civilian caught in the chaos. The accusations, however, are clear: she was a member of a terrorist organization. Then, as the caliphate crumbled, she found herself in a refugee camp, one of many Australian women and children trapped in a legal and moral limbo. The Australian government, under immense pressure, eventually repatriated a number of these individuals, including Rayyan El-Houli. The moment she set foot back on Australian soil, likely at a secure airport facility in Perth or Darwin. Before being transferred to Melbourne, she was immediately arrested. The date was sometime in late May or early June 2026, a return that marked the end of one chapter and the terrifying beginning of another, a battle not against an external enemy, but against the very laws of her own country, laws designed to protect the community from the threat of terrorism. The transformation from a suburban Melburnian to an alleged Islamic State member and then to an accused in an Australian court is a journey almost unfathomable to most of us. And it raises profound questions about allegiance, identity, and the limits of rehabilitation. The legal battle for Rayyan El-Houli commenced immediately upon her return. She was charged under specific provisions of the Commonwealth Criminal Code, particularly sections relating to being a member of a terrorist organization and engaging in hostile activities in a foreign country. These are charges that carry maximum penalties of life imprisonment, reflecting the extreme gravity with which Australia views terrorism. Her initial appearance was in the Melbourne Magistrates Court, the entry point for most criminal matters. Here the immediate focus was on her application for bail. This wasn't a simple bail hearing. The prosecution, representing the Commonwealth Director of Public Prosecutions, would have strenuously opposed it, citing the flight risk and, critically, the potential danger to the community. They would have presented evidence of her alleged association with ISIS, drawing on intelligence gathered over years. The defense, led by the experienced Peter Morrissey SC, faced an uphill battle. Their core argument, as revealed in court, was that Rayyan El-Houli had fundamentally changed. She had, in their words, renounced Islamic State and violent jihad. This wasn't just a legal maneuver, it was a declaration intended to sway the court to present her as someone no longer posing a threat. Morrissey would have argued that her time in the camps, her experiences in Syria, had led to a profound disillusionment with the group's ideology. He would have highlighted the difficult conditions she faced, perhaps even suggesting a degree of coercion or desperation in her original decision to travel. The stakes were immense. If bail was granted, she would return to the community, albeit under strict conditions. If denied, she would remain in custody, awaiting a trial that could span years. The court had to weigh the prosecution's concerns about national security and the protection of the Australian community against the defence's portrayal of a woman who had seen the error of her ways. This isn't just about guilt or innocence, it's about the predictive capacity of the justice system. Can it accurately assess future risk? Especially when the alleged crimes are so ideologically driven. The decision on bail, therefore, was not merely procedural, it was a profound statement about how Australia chooses to deal with its citizens who have been involved in such extraordinary circumstances. Ultimately, the resolution of Rayyan El-Houli's initial bail application was an adjournment. This meant that the court wasn't ready to make a definitive decision on her freedom. It provided more time for both the prosecution to prepare its case against her, perhaps gathering further intelligence or refining their arguments, and for the defense to assemble a more comprehensive picture of her current state of mind and her potential to reintegrate safely into Australian society. For Rayyan El-Houli, it meant continued detention, a harsh reality after years of living in refugee camps and under intense scrutiny. There was no immediate win or loss in that courtroom. It was merely a pause in a much longer, more arduous legal journey. The public declaration of renunciation by her barrister was a significant moment, a clear signal of her legal strategy, but it was not in itself a guarantee of a lenient outcome or even of immediate freedom. Justice in these complex terrorism cases rarely arrives in a single clean verdict. It's often a protracted process fraught with legal complexities, intelligence sensitivities, and intense public and political pressure. The question of whether justice was served or if it was a compromise will only truly be answered much further down the track after a full trial, where evidence will be meticulously scrutinized and the nuances of her journey examined in painstaking detail. For now, the legal system has merely taken its first tentative steps, leaving the profound moral and legal questions unanswered, hanging in the air, awaiting a deeper, more comprehensive reckoning. This case and others like it holds immense significance for everyday Australians. It speaks to the very heart of our national security, but also to the enduring concept of a fair go, even for those accused of the most heinous acts. What this means for Australians is that our laws, particularly the criminal code and its terrorism provisions, are robustly applied to protect the community. It highlights